Hello friends, so we are back with another video on an important topic related to Article 21 of the Constitution of India. Today's topic is Advanced Medical Directives. Friends, as all of us know, Article 21 of the Constitution deals with the right to life, right to live the life with dignity while protecting the right of privacy, freedom, definitely subject to the conditions laid down by the law. Now, when we talk about the right to life, to live with dignity, this right to life also includes in its compass the right to die with dignity. In regard to this right to die with dignity, there are certain procedures or certain scenarios which are recognized by various countries all over the world. When a particular person is suffering from terminal illnesses, or say he is brain dead, or he is on certain treatment which is going on for a very long time, and it is resolved or it is concluded by the doctor or by the treating physicians that there are very less or there are no chances of recovery now. So in such cases, the advanced medical directives will come into picture. There is a concept known as euthanasia, EUTHANASIA, euthanasia. The meaning of this term is enabling a person to die peacefully or to die without any pain or sufferings, or with much less pain or sufferings. This concept has been recognized since long world over. As far as our country is concerned, that is Bharat, an important decision of the Supreme Court came in the year 2018. This decision was in response to a writ petition filed by Common Cause Society, and in this writ petition the petitioner requested the court to issue proper directions so as to validate or so as to give legal backing to the process of allowing a patient or allowing a person to die peacefully or to die without much less pain or sufferings. So after going through all the practices which are recognized worldwide, the Supreme Court has validated the concept of advanced medical directives. Meaning of advanced medical directives is an adult person who is able to think properly and who is in a capacity to take informed decision, he can execute a document which is called Advanced Medical Directive. In this document, he will mention the conditions in which no medical treatment should be given to him, or if medical treatment is already being given, then it should be stopped. And this type of medical treatment also includes the life support system, that is to which we called ventilator in our layman language, ventilators. So this advanced medical directive, it is executed by a person. There are certain conditions subject to which this type of document can be executed by an adult person who is able to take the informed decision, who is able to take a conscious decision after evaluating all the pros and cons and after understanding the complete impact of this particular document. He can execute it. In that particular document, he needs to mention the conditions in which no further medical treatment should be given to him. He also needs to mention the name of the person or the representative or his nominee whose consent will be final consent in case when the time comes for the actual implementation of this advanced medical directive, at that relevant point of time, if the patient is not in a condition to communicate, he is not conscious at all, or he is not in a condition to take any decision, then the consent which is given by that nominee or that representative will be final. This nominee name, who can be his close guardians or relatives or close friends, their names should be clearly mentioned, their identifications should be clearly mentioned in the advanced medical directive. Beside that, the executor of this advanced medical directive needs to clearly mention that he is executing this particular document with complete consciousness, in an informed manner, and after understanding the whole pros and cons of this particular document. Now, beside this, 2 attesting witnesses are also required for execution of this document, and then this document also needs to be notarized. So in other words, this document needs to be executed and confirmed by the witnesses, executed by the executor and confirmed by the witnesses in the presence of a notary or a gazetted officer. Now, after executing this document, that person needs to deliver a copy of this document to the relative or his guardian whose name is mentioned as the nominee in that document. He also needs to deliver one copy of this document to his family physician and as well as to the custodian of the document. Now, this is a new concept, custodian, as far as this advanced medical directive is concerned. That custodian will be a competent officer who is appointed by the local authority of that particular area, which may be municipality, municipal corporation, or maybe Gram Panchayat. So that particular local authority needs to appoint one person who will be a competent authority and will be responsible as a custodian of these documents. Now, when that person who has executed this advanced medical directive, if he is required in the future to undergo any medical treatment, and if the condition so arises that he is under a prolonged medical treatment and the chances are very less or there are nil chances that there will be any recovery, or that person, if he or she is on a life support system, then in that case the treating physician, when he is made aware that such person has executed an advanced medical directive in the past, then that doctor or the physician will confirm the authenticity or genuineness of the document by asking for a copy from the competent authority who is acting as a custodian in that local authority. And after satisfying himself that yes, the conditions exist that this advanced medical directives can be executed. In other words, the further medical treatment to this patient should be stopped and he should be allowed to die peacefully or without pain or sufferings. In that case, he will hold a meeting with the nominee who is mentioned in that advanced medical directive. He will explain to that nominee the actual medical condition, what are the hopes of recovery, how much treatment is already given, what are the alternative methods of treatment, and what will happen if the treatment is stopped. And then, if that nominee gives the consent, then a primary medical board will be formulated by the treating physician. This board will have that physician itself, maybe family physician, and 2 another subject experts in that field, that is medical experts who are having at least 5 years experience. That primary medical board will also form its own opinion whether advanced directives needs to be executed or not after physically examining the patient and all the other conditions. And then the matter will be referred to the secondary medical board, which will include a medical expert who will be a district head or who will be a civil surgeon appointed by the government of that particular district. That is the medical district head, along with 2 other medical experts having at least 5 years experience. They will also form their own opinion regarding this advanced medical directive execution after examining the patient. And if both this primary board and secondary board, if they give their consent that yes, the medical treatment now should be stopped, then the intimation will be given to the judicial magistrate of that particular area, that is judicial magistrate first class or magistrate. And after that, after ensuring that the magistrate has been properly informed, the medical directives or advanced medical directives will be executed. In other words, the patient will be allowed to die peacefully without any further medical treatment or without any pain or suffering. Now, this we have seen the condition as to how the right to life, which includes in its compass the right to die with dignity, can be executed if the advanced medical directive is in existence. Now, the Supreme Court has clearly laid down that this right to die with peacefully cannot be made limited to only those persons who have executed this advanced medical directive. Even those persons who could not do this during their time when they were able to take the decision, this right should be extended or should be given to this type of patients also. So accordingly, the Supreme Court also laid down the procedure for this type of cases where a person is terminally ill, prolonged medical treatment is going on, or say the person is on life support system and there are very less or no chances or hope of recovery. Then the physician can inform the closest relative or guardian or friend of that particular patient who is taking care of that patient. They will take a meeting, means that physician, family physician and two medical experts having at least 5 years experience, they will hold a meeting with the relatives of the patient. They will explain them the whole conditions, and if these close relatives they give consent, then this primary medical board will form its opinion that now the further medical treatment should be stopped. And as already said, similarly, now the matter will be looked after by the secondary medical board. Again, it will include the district medical head and 2 other medical experts. They will also form their opinion. And if both primary medical board, secondary medical board and nominee all are of the opinion that yes, no further treatment should be stopped, then the intimation will be given to the judicial magistrate, and after that the treatment will be stopped or the life support system will be taken out and the patient will be allowed to die peacefully. So friends, this is one of the very important milestone achieved in Bharat or in India to further or to ensure furtherance of right to life, which is conferred upon everyone in Bharat by Article 21 of the Constitution. Now, one important point which should also be noted that in case the secondary medical board is of the opinion that no, medical directives should not be executed, or where there is no advanced medical directive, further treatment should not be stopped. But if the primary medical board or the doctor, treating physician or the nominee, they are of the opinion that no, now the treatment must be stopped, then against this rejection of their proposal to withdraw the medical treatment, when this proposal is rejected by the secondary medical board, then either the treating physician or the relative of the patient, they can approach the High Court under Article 226 of the Constitution of India by way of a writ petition. The reason being, this right to life, which also includes the right to die with dignity, is a fundamental right, and hence in order to ensure the protection of this right, they can approach the High Court, and High Court will decide the matter through a division bench. And the division bench may again form a committee, take the advice of medical experts in the relevant field, at least 3 medical experts, and they should have minimum 20 years experience. So friends, this was all about the right of advanced medical directives or the right to die peacefully. Hope you like this video. You can share it and you can also subscribe to our channel, Swatantra Legal Advocates. Thank you.